Well, good day, folks, and welcome to another edition of Lumberjack Logic. I'm your host, Neil Johnson. Excited to be with you. Really excited to share this with you. This is a website you're going to be able to go to. I'm going to give you a few highlights off it, but it's wiseenergy.org. I will link that below. But it gives you all the 2020 U.S. presidential election-related lawsuits. And, we'll see here what hey, by the way, if you haven't subscribed, please do that. But we'll see what YouTube thinks about this, because I am simply reading from lawsuits, okay? I'm not inferring anything, YouTube, all right? So here we go. These are all the lawsuits, and this will simply tell you how they were decided, were they decided on merits, the disposition, and so on. I'm going to give you something right up front here. I want you to know this. The disposition breakdown of the 87 lawsuits is this. That not decided on merit, 39 of them. To be determined or active, there's still 12 active lawsuits out there, folks. Trump's statutory wins, 17. Losses, 7. That means he's got more wins than losses on this, and voluntarily withdrawn is 12, okay? So I got to give a shout out to my friend Glenn, though, because he shared this to me. But here's the thing. I'm going to give you a couple examples. So people always say, well, they should have done more before the election. I mean, they didn't do anything about this, and these states are breaking these laws or whatever, right? Well, here we go. You'll remember some of these. I remember this one. Donald J. Trump for President, Inc. versus Buchvar, and that gives the case file. The date filed was 6/29 of 20. The topic was process. Was it decided on merits? No, it was in the state of Pennsylvania. Vote by mail, notice cure for mismatches, missing signatures or mistakes, witness requirements, failure to include ID or documentation, etc. The disposition on this case, it was dismissed for lack of standing on federal claims. Other claims did not have a statutory basis. So the case was never fully heard, and it's closed. Okay, so I just want to get that out there. So now I'm going to give you one here where there was a win. This is the RNC and Trump versus Miller. Okay, this is Iowa District Court in Lynn County. This is August 10th. This was on rules. It was decided on merits. Okay, it was vote by mail. Pre-populating ballots should not be allowed. Anyways, makes sense. Okay, granted injunction, Iowa counties were told to simply send blank ballots. Okay, that ruling favored Trump, obviously, and that is closed. I'm going to give you another one here. This is just going to kind of give you some basic. Donald J. Trump for president versus Philadelphia County Board of Elections, and then versus Philadelphia County. Okay, 10-1 and 10-15. Rules, it was decided on merits, okay? This was Pennsylvania. Poll observers were not allowed at early voting locations. That was denied on statutory basis. It favored the election administrator, so this was a Trump loss, okay? In that case is closed. But here, I'll give you another win. This was actually in Minnesota, my home state, versus Simon, vote by mail, mail voting deadlines for applying, receiving, and postmark. It was granted an injunction, sequestration of late received. That favored Trump and the GOP. And then, extended poll hours in Nevada, that was granted by Trump or favored Trump. That was actually on election day. So if you remember some of these cases, so I want to find one of my favorites. I've talked about this all the time, and now I got to go find it here quick. This was a post election. Oh, that's got to be down here. Okay. Oh, there we go. Wisconsin granted motion for TRO. Okay. So here's one. Jefferson versus Dane County. This is 3/27/20. Topic rules decided on merits. Yes. Misleading info regarding absentee ballots. That was granted motion for temporary restraining order. That favored Trump and the GOP. Okay. There's another one here. I'm not seeing it right now. I don't want to take up your whole time, okay, based upon this, but so then lots of dismissed, lack of standing, moot, so on and so forth. But I want to bring this up here now. So and this is a footnote on there, some non-merit reasons for stopping lawsuits from going forward are for A, standing, B, timing or latches, C, judiciary authority or jurisdiction, and D, moot, not enough malfeasance to make a difference. In each of these situations, the case was not fully heard. In U.S. Supreme Court cases, cert denied means that the case will not be heard, and the lower court's decision stands. This happens in 90+% of the cases, folks, going to SCOTUS. It does not necessarily mean the Supreme Court agrees with the lower court's ruling, okay? And in the dismissed, moot, or cert deny cases, the majority of their judges did not state why they would not hear these cases. However, Judge Thomas wrote strong arguments against denying cert here and objected to other judges using moot as an excuse, okay? And if you remember that, he wrote a blistering dissent. It was phenomenal. So, but this is really just a phenomenal report. I'm going to post this link for you, folks. I want to thank you for listening to Lumberjack Logic. Please subscribe if you have not. Like this video, get this out. I think this, here's the thing. You're always talking with your liberal friends and they're saying, oh, these cases they heard all these cases and they were just, nothing. No, most of them were not heard, and he actually had more wins than losses, and it's a narrative that's getting lost out there, people. I want you to get the word out on this. So thank you so much. I look forward to seeing you on the flip side.